Hello, and welcome to our training on updates to the CARE Act made by Senate Bill 27. We'll be going over these changes at a high level and how they will impact different parties involved in care. So it's just a high-level overview of these changes, and we do have a brief that's available on the CARE Act Resource Center. So these updates are effective January 1st, 2026. And again, some of those made by Senate Bill 27, some of those include the addition of bipolar 1 with psychotic features, defining what clinically stabilized means, a process for certain court referrals, and the ability of criminal courts to consider care referrals earlier in the process. And then the authority for nurse practitioners and physicians' assistants to complete affidavits in support of a care petition, and then a few other technical amendments to streamline care. So for more information about these changes, you can go look at our brief, but also request some training and technical assistance at info@careact.org. And just a note that the data dictionary will be revised to align with Senate Bill 27, and those changes will be implemented by July 1st of 2026. But the provisions outlined in Senate Bill 27 do go live and are effective on January 1st, 2026. So briefly look at our agenda. We're going to first discuss the expanded eligibility criteria and then talk about the streamlined court-to-court referral pathway, another pathway that courts can take to make a care referral, and then some key process updates. The objectives is that you'll have an increased ability to recognize that bipolar 1 disorder with psychotic features is an eligible diagnosis, understand those streamlined referral pathways, and then be able to summarize some of the other updates and how they may impact county processes. Today's presentation will be done by Leela Kapoor, who is a mental health law lead and is an attorney with more than 30 years of public service, and we'll be walking through these changes. So Lee, let's turn to you and you can walk through the provisions of SB 27.
Thank you, Patricia. Yeah, let's get started. So we're going to start talking first about the changes regarding eligibility criteria. Most importantly, the SB 27 added bipolar 1 disorder to the eligible diagnoses for the CARE Act. Previously, eligible diagnoses were limited to schizophrenia spectrum and other psychotic disorders. SB 27 adds bipolar 1 disorder with psychotic features, except for psychosis related to current intoxication. You need to remember, however, that having a specific diagnosis alone is not sufficient to participate in care. The CARE Act continues to have additional criteria regarding the person's current treatment engagement, level of functional impairment, and certain risk criteria. While SB 27 broadens eligibility to include bipolar 1 with psychotic features, not all individuals with this diagnosis will meet all the other care criteria, and other less restrictive alternatives could be a more appropriate avenue for them to receive treatment. If you'd like some more information, you can look at our updated eligibility fact sheet, which includes the bipolar 1 with psychotic features eligibility criteria, and there's also some frequently asked questions that you can refer to. The other thing around eligibility that SB 27 did was it defined clinically stabilized. The CARE Act process is designed to support individuals with serious mental illness who are not currently stabilized in ongoing voluntary treatment. As defined in SB 27, an individual is considered clinically stabilized in ongoing voluntary treatment if both of the following conditions are met. The individual's condition is stable and it is not deteriorating, and the individual is currently engaged in treatment and is managing symptoms through medication or therapeutic interventions. It's important that enrollment in treatment alone is not enough. The person has to be currently engaged and active in that treatment. So those are the changes brought by SB 27 regarding eligibility. Now let's turn to some of the process changes, starting with the expanded referral pathways for care. SB 27 provides a more direct pathway for referrals from assisted outpatient treatment, you may know as AOT, Latterman Petrus Short LPS conservatorship proceedings, and felony and misdemeanor incompetent to stand trial courts, the IST courts. A referral from one of these courts may now be accepted as a petition for care without a separate petition form if it meets two conditions. First of all, referral includes all the required information as outlined in Welfare and Institutions Code Section 5975. Mainly what that means is that it includes all the facts that support the assertion that the individual meets the care eligibility criteria. And the referral makes a prima facie showing that the individual meets or may meet care eligibility criteria. It is up to the care court to determine whether or not the referral meets these conditions. If the care court deems the referral to be a petition, the care court shall notify the referring court that the referral has been accepted as a petition, and the petition is going to proceed through the care process as any other petition would. If the care court does not accept the referral as a petition, it shall order the appropriate petitioner candidate, and we'll discuss what that means in just a second, but the care court shall order the appropriate petitioner candidate to do the following within 14 court days. They are to investigate whether a petition should be filed, and they are to notify the referring court whether they intend to file a care petition. The care court may grant an extension of up to 30 court days if more time is needed for that investigation. So let's talk about who the appropriate petitioner candidates are. For AOT, misdemeanor IST, and felony IST referrals, the county behavioral health director or their designee is the appropriate petitioner. For LPS conservatorship proceedings, those referrals, the conservator or the proposed conservator is the appropriate petitioner. So let's take an example. In this example, the IST court makes a direct referral to the care court. The care court reviews the referral, and if the care court determines that the referral is sufficient to be deemed a petition, the care court notifies the IST court, and the petition proceeds through the care process. If the care court determines that the referral is not sufficient to be deemed a petition, the care court in this example, because it is an IST referral, shall order the county behavioral health agency to investigate and to notify the IST court within 14 court dates as whether or not it intends to file a petition. This streamlined direct court-to-court referral process is in addition to the current referral process that allow AOT, IST, and LPS conservatorship courts to make referrals that flow through county behavioral health or the conservator or proposed conservator. This process, therefore, is in addition to the current process. So if your county and courts already have a process in place, you can continue with that process, or you can take the option that is provided for in SB 27 through this court-to-court referral process. Moving on. SB 27 also allows for earlier referrals from missed courts. Previously, the Penal Code allowed for a criminal court to refer to care an individual charged with a misdemeanor who has been found incompetent to stand trial after they were found to be ineligible for or unsuccessful in mental health diversion. SB 27 allows a missed court to consider the individual's eligibility for care earlier in the criminal court process at the hearing held after the initial determination of incompetency. Specifically, the criminal court may refer the individual to care if the individual or their counsel agree to the referral, and the court has reason to believe the individual may be eligible for care. The following process will apply with these referrals. The care court shall hold a hearing to determine eligibility within 30 court days of the referral. If the hearing on eligibility is not held in those 30 court dates, an individual in county jail shall be released pending the hearing. If the individual is accepted into care, the care court shall notify the criminal court, and the charges shall be dismissed 6 months after the date of the referral to care, unless the case is referred back to the criminal court prior to that time. Keep in mind the criminal court has the discretion to both grant diversion and make a care referral at the same time. Also keep in mind that a missed court retains the ability to make a care referral of an individual if that individual is ineligible for or has been unsuccessful in diversion. SB 27 clarifies the process around those referrals. It provides that the care court shall hold a hearing to determine eligibility for care within 14 court dates after the petition is filed. If the hearing on eligibility is not held in those 14 court dates, an individual in county jail shall be released pending the hearing. Similar to the earlier missed referrals that we just discussed, if the individual is accepted into care, the care court shall notify the criminal court and the charges shall be dismissed 6 months after the date of referral to care unless the case is referred back to the criminal court prior to that time. So now we're going to move on and talk about FISTs. These are the incompetent to stand trials for individuals who have been charged with a felon. And SB 27 made some slight clarifications that help with these referrals. So referrals from FIST courts were previously provided for in the penal code, but they were not specifically provided for in the care statute itself. So SB 27 specifically includes this referral pathway in the care statute. And by doing this, this allows for the FIST and care courts to communicate regarding the status of a respondent's case and any relevant court orders while the cases are pending in both courts. So this is a clarification that allows for that communication to occur between the FIST and the care courts. Lastly, SB 27 added some clarifications regarding the court process. So we're going to talk about those next. Specifically, SB 7 introduces several key updates to the CARE Act that refine the court procedures and clarify roles with the process. First, SB 27 provides that nurse practitioners and physician assistants are considered licensed behavioral health professionals, but only for the purpose of signing an affidavit in support of a care petition. So under these amendments, a nurse practitioner or physician assistant may sign the affidavit, which is sometimes referred to as the Care 101 mental health declaration, which is filed in support of a care petition, often the Care 100 petition. It is really important to know that SB 27 does not allow that nurse practitioners and physician assistants are eligible to complete the clinical evaluations that are required as part of a care plan process. SB 27 also confirms that a care court may make the initial preliminary finding that a petition meets or may meet eligibility requirements without holding a hearing. This is the prima facie determination that is made by the care court for petitions, and SB 27 just confirms that the care court may make that determination without holding a hearing. Currently, the CARE Act requires a single progress hearing at 60 days following the adoption of a care agreement. SB 27 confirms that a judge can hold additional progress hearings throughout the duration of a care agreement. So SB 27 confirms that the judge has the discretion to hold more than one a progress hearing for a care agreement if the judge so chooses. SB 27 clarifies that while a respondent may request to graduate from care, the individual needs to have successfully completed the care process for the court to grant that request. Similarly, SB 27 confirms that while a respondent may request to be voluntarily appointed to care, the court may approve the request after determining that the individual has not yet successfully completed the process and would benefit from reappointment. So SB 27 just clarifies the judge's role in the graduations and voluntary reappointments. And finally, SB 27 clarifies that if a respondent is enrolled in a federally recognized Indian tribe, the county, not the respondent, is responsible for providing notice of a case management hearing to the tribe, subject to the respondent's consent. So SB 27 just specifies that it is the county and not the respondent that is required to provide that notice. So with that, that's SB 27 at a high level, and I'm going to turn it back to Patricia.
Thanks, Leila. So again, the objectives of this training is that you would have an increased ability to recognize uh, bipolar 1 with di psychotic features as an eligible diagnosis for care. We do have a number of trainings and resources available regarding this diagnosis and how it could impact the county. So please um, consult a Care Act Resource Center, and you can also reach out with the email address we'll provide on the next slide to better understand that diagnosis. You also, the goal is to have a better understanding of those streamlined referral pathways from those specific courts, including what's required for a referral to be deemed a petition. And then also that you would better be able to summarize some of those process updates, including the added role of nurse practitioners and physician assistants, procedural clarifications around certain hearings and notice requirements to federally recognized tribes. So all of our resources on careact.org, including the training materials for this training with notes where you can find more information and links to resources, but there really is no wrong door. So if you have any questions about SB 27 or impacts to the care process or any other topic, you can go ahead and reach out to us at info@careact.org and we can point you in the right direction.